Hello, my beautiful friends. What an amazing day it is. We've got a big one from the Supreme Court today. 6-3 on racial gerrymandering now coming to a close. We'll go through the latest. Lots of reaction on this one. We know it's a good one because the Democrats are melting down, furious that the Supreme Court handed this down today. We've got reaction from Nancy Pelosi, Hakeem Jeffries, Barack Obama, all of them calling this catastrophic and fatal is what Nancy Pelosi says, which means it is justice. It's actually a good decision if they hate it. So we'll go through it. We'll hit the highlights of the decision. It's from Justice Alito, always a banger from him. And we'll see what some of the arguments in the dissent are. And then, of course, break down what the president had to say about this from the Oval Office. Then we'll get an update on what's going on with Cole Allen, the attempted Trump assassin who broke into the White House Correspondents Association dinner. New filing today from the DOJ on that one, showing some new evidence. He is, of course, going to try to get out of custody. The DOJ submitted their brief saying why he should not be released from custody and why he should be detained. We'll take a look at that. And then Comey surrendered to court today, and we'll go through the latest there. We'll see if there's any new updates to the docket. There weren't as we started the show, but we'll save that for the end to see if it gets populated. But this means he really wasn't arrested, as far as we can tell. Went into court, self-surrendered. We've got a lot of reaction on that as well from Kennedy, from the president, and from others. And so we're jam-packed today. Thank you for being here. Thank you for subscribing to our channel and all the things. My name's Robert Gouveia, formerly practicing criminal defense attorney. This is Watching the Watchers, and we're very glad to have you here. We always like to confirm that the tubes are working before we jump into things, especially when we're on the road and we are in a new location. We'll be back in our home base tomorrow, and it looks like we're live. That's tremendous news. That means we can get started. So let's do it, shall we? Starting right here. Major Supreme Court victory that ends racial gerrymandering. The idea that you would carve up a state and you'd group people based on their race in order to give them specific districts feels almost like racism, because it is. That's what the Supreme Court decided today in a 6-3 decision handed down by Judge Alito. The case here is Louisiana versus Philip Calais. I think it's French or something. And of course, we're going to go through it and see what it says, break down the legal arguments, and take a look at what both sides are saying here. But 6-3 is a nice one. That's going to mean it's the conservative appointed judges in the majority, the 3 dissenters in the minority, and they're very furious about this. And just to show you how significant this is, we have this post from Nancy Pelosi. She shared today that this is fatal. This is going to be basically the end of, I guess, their power. She said, today, the Supreme Court has dealt a devastating new blow, which means nice, to the Voting Rights Act and against the sacred right to vote, which it doesn't at all, as we'll explain. The consequences will be felt across the country. Fewer voices heard, she says, fewer communities represented, and a democracy diminished. She says Congress must urgently pass another Voting Rights Act amendment to restore the full strength of this before this latest blow becomes fatal. That's from Nancy Pelosi. And she's joined by a bunch of the other Democrat leftists who are calling this the end of voting in America, even though it's nothing of the sort. Of course, we have Senator Eric Schmidt, who gave us a very nice high-level breakdown. So before we dive into the opinion, let's make sure we understand our orientation and then zoom into it, because it is a technical decision from Alito. He walks us through the history of the Voting Rights Act, the 15th Amendment, and the procedural history on this one's kind of complicated because we have maps that are approved and then someone sues and then the maps are reversed and then someone else sues. And so basically nobody was happy with the maps. But here's the breakdown. Eric Schmidt shared, Louisiana versus Calais is a redistricting earthquake. He's a senator out from Missouri. He said each district drawn that used race is now unconstitutional. So the idea would be you'd want to put all of, in this case, the black people together, and then they would get their own district. So a majority minority district where the majority of the people are from a minority group. He says Section 2 now of the Voting Rights Act can be used to challenge those districts. So originally the idea was, you could draw or had to draw majority minority districts in order to comply with Section 2 of the Voting Rights Act. Now, not anymore. Disparate impact theory is also unconstitutional, so we'll get into that as well. He said the Voting Rights Act of 1965 was enacted to ban racial discrimination in voting, but rather than enforce that discrimination ban, the Supreme Court back then greenlit the left's twisting of the VRA into a mandate to create every possible racially gerrymandered majority-minority district. In other words, it was enacted to prevent the discrimination. But they said if you didn't do this, if you didn't create these special districts, then that in and of itself was discrimination. So you had to create these special districts or else you were being racially discriminatory, even though you weren't doing anything that was racially discriminatory other than just drawing districts. They said you were disenfranchising people, and so you had to create these special districts using race as a measure. And of course, anytime you use race in America, it is subject to strict scrutiny in most cases, and for good reason, because we don't want to carve people up by race. That's racist. So he says the engine behind that was Gingell's, a Gingell's case from 1986. And they took that case and perverted it and used it to argue that if a majority minority district could be drawn and voting patterns were racially polarized, then Section 2 required the state to redraw it. So if some districts had more white people or black people did not have their own district, that was racism in action. So the result was racial map making by lawsuit. Then people would sue. They'd say you have to, bundle up all these people into one group and give them a district. So now we've got Louisiana versus Calais. Louisiana was pressured to draw a second majority black district. So someone sued, they drew maps, someone sued, said, this is a racist map. This is disenfranchising black people who need an additional district. So then they gave them a second district and used race specifically in order to draw that second district. Then other people sued and said, what's going on here? Seems like you're using race in order to carve up these districts. Now today, SCOTUS held that the district unconstitutional, the new one, because race drove the map. Section 2 does not require that you use race in drawing the maps. He said each district drawn using race is now constitutionally exposed. In other words, it could be unconstitutional. So if you carve these racial districts into the maps, that was using race, that would be illegal. If race drove the lines, then strict scrutiny applies. And if you've been around here for a while, we talk about this a lot as we cover a lot of constitutional law. But we've got these different levels of scrutiny. When you have the government passing laws that infringes on rights, we ask ourselves, well, what right is being infringed and or what classification or what is the law doing? And if you have certain laws that impact things like race or national origin, then what you have is strict scrutiny. But for other laws, you might have rational basis laws, which means as long as the government is not infringing on some constitutional provision, as long as they have some rational basis for passing that law, they can do it. Because it's not targeting something like race, for example. If it does target race, we leave reasonable basis and we go up to strict scrutiny. And if Section 2 did not actually require the racial district, then the district cannot survive. So this is a massive equal protection reset. We'll look at the decision. He says now this law can be used to challenge these districts. For decades, activists would come in, they would sue under Section 2, they would force these districts into existence, but now litigants can argue the opposite, that the Voting Rights Act did not require racial sorting. They used it to impose these districts by saying if you don't have them, then the absence of that district is racist. Third, the disparate impact theory also took a major hit today. 15th Amendment targets intentional racial discrimination in voting. It does not authorize courts to treat every racial disparity as a command to go in and fix the racism, in other words. So what does this look like practically? This is why this is so consequential and why Nancy is melting down over it. Take a look at the heavily Republican South. You see the map. VRA has artificially inflated the Democrat representation by at least 12 seats over the last few decades. So they go to Mississippi, they go to Alabama, they go to Georgia. We've got reaction from Georgia. A lot of these states are now saying we need a special session to fix this problem. South Carolina, Florida, Louisiana is where we're going to spend most of our time today. North Carolina. all had people sue to say, if you don't have a district that is blue like this, then you are a racist in violation of the Voting Rights Act. Now it could look like this because those forced districts are no longer constitutional because they're racist, because they're using race to carve these districts out. So it's a big shift. Currently, Democrats holding 24 seats in these states, possible redistricting scenario. Republicans go up plus 12. And that's why they're so upset about it. So he continues, he says, and let's not forget about what the Democrats have already done here. Compare that to New England, where it's a bunch of Democrats up there, which has successfully denied any Republican representation across its many districts over the past several Congresses. This is what it looks like just up north, in case you're unfamiliar. Many of these states have 30 to 40 to 45% Republicans. How many seats in Congress do those Republicans get in terms of representation? Zero. Not any. Connecticut, Rhode Island, Massachusetts, New Hampshire, and Maine, all blue, even though there's not only blue people there, there's a bunch of reds, in some places 40%, but zero representation in Congress. So he says the path forward is very clear. Now it's time to challenge racist districts, force the plaintiffs to prove that race, not politics, were involved in the maps, and reject this map making, saying the VRA protects voters from discrimination. It does not carve America into racial spoils for Democrat advantage. So a nice summary there. Let's take a look at the actual decision delivered by Justice Alito for the court. And he walks us through a lot of details, so we'll fast forward through some of the stuff that is unnecessary, but he gives us a background. He says Section 2, which is the subject of this decision, was passed in 1965, and it was designed to enforce the Constitution. We had the 15th Amendment he'll get into. This was to supplement that and to enforce it, but not to undermine it and not to collide with it. But unfortunately, lower courts have sometimes applied this court's precedents in a way that forces states to engage in the very race-based discrimination that the Constitution forbids, carving up the country based on racial lines. So this tension between the Voting Rights Act under Section 2 and the Constitution came to a head. What happened here is Louisiana, we've got a bunch of maps we'll look at, redrew its congressional districts after the 2020 census. We got new numbers, people moving between different states, they have to redistrict. In 2022 then, a federal judge in the Middle District of Louisiana said that the new map that was adopted by the state after the census likely violated Section 2, the Voting Rights Act, because it did not include an additional majority black district. So they said this current map isn't sufficient and it's actually racist because it's discriminatory because it's not giving another majority black district. When the state drew a new map that did create that district, its new map was also challenged as a racial gerrymander. Okay, so then new map comes down, black people sue. They say, hey, you're depriving us of a district. They draw a new map. The new district is literally based on race because the judge said so. Said you have to go give black people another district. So then the district is created, clearly based on race. Then other people who are non-African Americans, and I'm using these words because they're part of the case, they sued non-African Americans and said, you literally created a racist district. Then a 3-court judge in the Western District of Louisiana held that the new map did actually violate the Equal Protection Clause, and the state appealed to this court. So the new black majority district violated equal protection because it's treating one group of people differently than another group of people under the Constitution, not under the Voting Rights Act. So the parties originally briefed this, and they argued this suit last term, and their arguments at that time highlighted problems in the case law under the Voting Rights Act. One problem resulted from the rule that in racial gerrymandering cases, unlike other cases involving claims of racial discrimination, strict scrutiny, which is the standard that we normally apply when we're talking about race, and it's a very high standard. Like the government can only do racial discrimination if a couple, in very limited instances. Otherwise, it's illegal. It's unconstitutional. And they said, well, for voting, it's a little bit different. It's only triggered if race predominated in the state's decision-making process. Now, in this lawsuit, Louisiana adopted the challenged map and created a second majority black district because it reasonably said if it didn't, then the middle district of Louisiana, the court would order the use of a map that would shake everything up and it would oust incumbents and it would undermine what the legislature actually wanted. So they said, okay, I mean, we don't want the judge to redraw the maps, so we'll draw and add in a second black majority district. Under our existing case law, then, that situation posed the question whether race or politics was the state's predominant motivation. And in the redistricting and gerrymandering case, politics is perfectly allowed. You can use politics to carve everything up. We saw that happening in Virginia. It's happening all over the country right now. Now, another problem stemmed from this. The long unresolved question about whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing legislative districts. For over 30 years, we assumed, the Alito writes, for the sake of argument, that the answer to that is yes. And we have gone further and assumed that it is enough if a state has a strong basis in evidence for thinking that the Voting Rights Act requires race-based conduct. Okay, so in other words, if you don't draw a majority minority district, that could be racism. But allowing race to play any part in governmental decision-making represents a departure from the constitutional rule that applies in almost every other context. We don't have racist laws in America. In this case, they said, well, we kind of do, and we kind of will allow it. So these and other problems, writes Alito, convinced us that the time had come to resolve whether compliance with the Voting Rights Act can indeed provide a compelling reason for race-based districting. And we now answer that question. Compliance with Section 2 in italics as properly construed can provide such a reason as properly construed, not in the original interpretation as it was for the last 30 years. They were misconstruing it, so they're not overruling Section 2 outright. They're just saying, you guys misinterpreted it this entire time, so let me explain how it actually works. So correctly understood, voting rights does not impose liability at odds with the Constitution, and it should not have imposed liability on Louisiana for its 2022 map for not being, I would say, racially inclusive enough and adding in the black majority additional district. Compliance with Section 2 thus could not justify the state's use of race-based redistricting here. So saying you have to draw another race-based map or else you're in violation of Section 2. The state's attempt to satisfy the ruling, although understandable, by adding in a new district, was unconstitutional. It was a racial gerrymander, and so therefore we affirm the decision, and you can't do that. He gives us a bunch of background here, and we'll fast forward through some of this, but he says, originally, the 15th Amendment after the Civil War was ratified in 1870. It said that right of citizens of the United States to vote shall not be denied or abridged on account of race or any other previous slavery or color. For many years, there was a bunch of suppression. We had literacy tests and poll taxes and property qualifications and all of these things, even all the way going up into the 1960s. And states employed redistricting schemes that would prevent black candidates and others from getting to vote. Now, Section 2 also authorized Congress to pass legislation to enforce the 15th Amendment. They did that. They passed the Voting Rights Act. It's gone through a bunch of different adjustments and improvements and deletions and other things. We had a case in the 1980s called Mobile versus Bolden. The court interpreted the language and gave us a bunch of different standards and a bunch of different rulings. Congress had concerns about some of these. We have this concept called proportionality. Congress was a little nervous that the idea would be we would have to invoke racial proportionality in elections. So in other words, we would cover and cut people into groups. So we'd say, okay, here's one state, 100% of the people, we have 60% whites, we have 20% blacks, we have 5% Asians, 10% Hispanics, whatever. And then you'd have to figure out how to carve out the maps in order to give everybody their appropriate share of representation, right? Every race would have a proportional seat in Congress. They were concerned about that. So the final bill in this debate back in the 1980s said that we have a disclaimer against proportionality. Okay, we're not doing that in this country. We're not saying, okay, you have this many, blacks, this many Hispanics or Latinxes or whatever. you get a certain number of seats. So that made its way in, and there were provisions that say you have to look at the totality of the circumstances. And it comes down to this, really, whether your members have certain opportunities to participate and to vote in the election. Goes through additional case law, fast forwarding through White. He's walking us through the background. We're obviously going to get to the decision. Then we had an amended version of Section 2 in this Gingles case in 1986. Gingles was about a challenge in North Carolina, and Justice Brennan, he didn't really even analyze the statute. He went right back into, says Alito, in his analysis, and he went to the Senate Judiciary Committee report and then based the rest of his analysis on the Judiciary Committee report. He gives us what the Gingles court taught us. He said, well, if you want to have a violation of Section 2, he articulated these 4 standards. And in later cases, we had redistricting plans that states created were also challenged as racial gerrymanders. So we fast forward through a lot of the history. This court approached those cases building on the framework for other discrimination cases. In those cases, if you had race that played a role in a decision made by the government, period, okay, strict scrutiny applied. The government had to meet an extremely high standard to justify that racial discrimination, to treat black people differently from white people, differently from Asian people, different. You get it. Under this standard, the strict scrutiny standard, the government needed to assert a compelling interest that justified its use of race. Got to be extremely compelling. Not like, well, you know, we're trying to make it more convenient. It's not really compelling. It's got to be critical. And if the analysis progressed beyond this point, the government then also had to show that its use of race was narrowly tailored to achieve and to vindicate that interest. It's the highest standard that we have. So the court modified, though, the framework for racial gerrymandering. Strict scrutiny applies in all other instances where the government is carving people up by race, but not for this one. The court modified this framework for racial gerrymandering. Now, although any use of race in government decision-making generally triggers strict scrutiny, in gerrymandering, these cases, a challenger must show that race was the government's predominant consideration. And in cases where race did predominate, states would sometimes assert that compliance with the Voting Rights Act provided a compelling interest that justified the use of the race, saying, we know that we're carving this up by race, but we're just following the law. The Voting Rights Act says we have to. And if we don't carve out these specific districts, then we are being racist and discriminatory. Yet we never decided, writes Alito, whether compliance with the act would constitute a compelling interest. Instead, we repeatedly assumed, this court over the last however many years, without deciding that the Voting Rights Act could be a compelling interest, because in all those cases, the act actually did not demand the state's race predominant districting. Thus, the states in those cases could not satisfy strict scrutiny, regardless of whether compliance with the Voting Rights Act could provide a compelling interest. He goes through some other cases here. Talks about Miller versus Johnson in 1995 and gives us some background on that. Same analysis in Shaw versus Hunt. Similar analysis in Alabama legislature. He said, we applied strict scrutiny to a race predominant districting plan that the state had created for 2 purposes. They said, one, first, in 2015, we want to come close to a 1-person, 1-vote ideal, and we want to ensure compliance with the Voting Rights Act. We held, even if the Voting Rights Act could provide a compelling interest, the map did not satisfy strict scrutiny. The map failed because it was not required by the act. And we left open a bunch of questions. Same thing in Cooper. And he walks us through. That was the legal framework in place when these lawsuits originated and landed on the Supreme Court's desk. Now he's going to explain how to interpret it now. Now, as noted earlier, the underlying litigation in this suit resulted from Louisiana's response to population changes. We had the 2020 census. The subsequent reapportionment of House seats among the states left Louisiana with the same number of seats. They still had 6 that had previously been allocated, but the population moved around, and so they needed to recalibrate the districts. Here's a map from 2013 to 2022. We got District 1, 2, 3 over here, 4 up here, 5, and then 6 right here in the middle. He explains, in 2022, Louisiana enacted a new map called HB 1. That closely resembled its immediate predecessor, seen here. He continues, now like its predecessor, it had only 1 district in which black voters were a majority of the voting population. In the above maps, it is the bat-shaped District 2 that includes much of New Orleans. And so this one right here does kind of look like a bat that you see like Batman's throwing star. Saying, as soon as HB 1 was enacted, lawsuits were filed in Louisiana. They said, you guys are packing all these black voters into a single majority black district, and you're cracking the remaining voters among the other 5 districts. After the lawsuit was filed, the lower court issued a lengthy opinion saying, yep, you are failing to include a second majority black district, and that, of course, is racist, and that's in violation of the law. The court then entered a preliminary injunction, went back, required Louisiana to draw a new map. Back then, the election was just 6 months away. So Louisiana said, we don't want you to force us to draw a new map. They appealed. Now, because of outside circumstances, the appeal ended up in limbo. The court granted cert a while ago. A bunch of cases were kind of stacked into one here. Nearly a year later, after deciding, the court dismissed this and remanded. By that time, the 2022 election had already passed, and the urgency that had justified the preliminary injunction was no longer present. In a tentatively worded opinion, they issued another one. They said the injunction is no longer needed. They remanded it back down. They said, Louisiana, now there's no urgency, but you still have to go draw a new map. If Louisiana failed to do so, then they would draw the map in the court. After the remand, Louisiana did not have many options. The district court held that the plaintiffs, the people saying we need another black district, were going to win. And their argument was that the Voting Rights Act required a new district. So if Louisiana didn't do it, the district court would draw one and then force them to use it. Wishing to avoid that, then Louisiana drew its own map. After a process, Louisiana enacted this new map called SB 8, seen here on your screen. So same number of seats, but stuff just moved around a little bit. And you can see this district kind of got a lot bigger, and it's kind of encompassing this whole area, District 6, into parts of New Orleans. And we still have mostly the bat shape here. And we've got District 1, which kind of curly cues around the bat. This retains the original majority minority district in yellow in number 2. It then adds an additional majority minority district, number 6, in green, this one that we just drew right here. So that's both of these, number 2 right here and number 6 are going to be majority minority, mostly black. To attain this, it connects black populations from Baton Rouge up to Lafayette with other people in Shreveport. And this is the new map they drew. Here are a couple of plans they put together. You can see multiple permutations in order to achieve this outcome. They illustrate here a second majority minority district, but with various different maps, okay, various different ways in order to accomplish this. So this goes through, it connects urban black communities with more rural black communities. And he walks us through all the various, differences, different parts of the locations that are being connected. And this was a concern because they did not want to gerrymander out Mike Johnson. He's the House Speaker, House Majority Leader Steve Scalise, the Appropriations Committee member Julia Letlow. They wanted to make sure that those districts could stay intact. And so they had a bunch of different options. So then after SB 8 was enacted, another lawsuit is filed. So first judge says, draw another majority black district. Then that goes into effect. Then other people who are not majority black sue. They said, this is racism. This time in the Western District of Louisiana. A group of plaintiffs called the Calais plaintiffs asserted that SB 8 was literally a racial gerrymander, and that violates equal protection clause because you're carving out one group an additional seat based on race, literally. The judge ordered it. They intervened, the Robinson defendants, seeking to defend the decision to draw the new map. Because the Calais plaintiffs challenged the constitutionality of this, we held a panel, district court, 3 judges convened to hear the suit. The court held a 3-day preliminary injunction hearing. It was consolidated. So they observed, they said, well, this second majority minority district stretches 250 miles. It slices through metro areas to scoop up pockets of black people. The court concluded that the map effectuated and affected a racial gerrymander. That violates the equal protection clause because you're trying, as you can see, to just specifically go find them, essentially. You want to go find them and put them into a district based on their skin color. And they did that, exactly. So the Court of Appeal says, that's pretty much racism. After an initial round of briefing, this went up to the Supreme Court. We ordered supplemental briefing. We asked the question whether the state's intentional creation of a second majority minority district violates the Constitution. And because the state's intentional creation of a second majority minority district prompted by an order, our question implicated the correctness of this longstanding assumption. Can you use race as a basis for government action? We know the answer is normally no. In like 99.9% of the time, you can't use race to effectuate governmental policy. This question was pending in several lower court cases, so we decided to hear the case. Alito continues. In considering, in Section 3, whether the Constitution permits the intentional use of race to comply with the Voting Rights Act, we start with the general rule that the Constitution almost never permits the federal government or a state to discriminate on the basis of race, period. Such discrimination triggers strict scrutiny. And our precedents have identified only two compelling interests or reasons that can satisfy that standard. One compelling interest, which is not relevant here, is in prison. Okay, you can segregate people by race in prison when there's a race riot. There is a compelling interest to make sure that the Aryans don't kill the blacks and the blacks don't kill the Latinos and the Asians don't kill, and the only way to solve that is to separate them. That's it. So we can separate people based on race. We have a compelling interest to do it. There's no other alternative, so we'll allow it in that one. The only other compelling interest that we have found is remediating specific identified instances of past discrimination that violated the Constitution or the statute. And again, that's not really here. Now, to rise to the level of a compelling state interest, an effort to remediate past discrimination, you have to have two conditions, he explained. So the first one, this is not prison. Let's talk about the second one. First, the discrimination must be identified discrimination. In other words, the state or federal government must identify the specific instances of past discrimination that it wants to fix. In light of that specification, then, they must determine the precise scope of the injury that it seeks to remedy. The states and federal government have no compelling interest in generally remediating past discrimination, generally speaking, or the effects of societal discrimination. It's got to be specific. And what is the scope? Second, after identifying the specific instance of discrimination, the institution that makes the racial distinction must have a strong basis in evidence to conclude that remedial action is necessary. He cites a bunch of other cases for us. Our acceptance of race-based state action has been rare for a reason. We don't do this. Distinctions between citizens solely because of their ancestry are, by their very nature, odious to a free people whose institutions are founded upon the doctrine of equality. And in redistricting, where the state assumes from a group of voters race that it's racist, that they all think alike, share the same political interest, will prefer the same candidates at the polls, it is literal racial stereotyping to say, well, all the black people all play along together and all vote the same. So put them all together at odds with equal protection. So the question before us now is whether compliance with the Voting Rights Act should be added to our very short list of compelling interests that we can justify to use racial discrimination, like in a prison. To answer that question, we must understand exactly what the Voting Rights Act demands with respect to the drawing of these districts. And so therefore, we read the text. He gives us the paragraphs of the text. No voting qualification shall be imposed in a manner that results in the denial or abridgment of the right of any citizen to vote based on race or color. A violation here is based on the totality of the circumstances and certain participation and more. So this is not the easiest language to parse, he says, and we're going to break it down in steps. So we'll just follow along. Beginning with subsection A, we take as given that a legislative map may constitute a standard practice or procedure. So that's true. If that were not so, there would be no basis for any of our vote dilution cases, and we've had many of those. And in this complicated verbal formation, the key concept for present purposes is whether there is less opportunity than other members of the electorate to elect representatives of their choice. Less opportunity. This language, writes Alito, sets a baseline against which to assess the opportunity of minority voters. Do they have an opportunity to vote that other members of the electorate have to elect their preferred candidates? To understand this baseline, we have to understand what less opportunity means. What does it mean to elect? What do other members of the electorate mean? In isolation, opportunity could refer to either a desired outcome or a chance to achieve that outcome. However, opportunity must mean a chance to achieve the desired result, because the Voting Rights Act does not guarantee equal outcomes. And so less opportunity must mean lesser chance. And so less opportunity often takes on that meaning. One might say, for example, that men under 6 feet tall have less opportunity to play in the NBA. I know, I wanted to do that. Than those who stand at least 6 feet 7 inches, which is the current median. In the NBA, that's tall. The next term, other members of the electorate, it specifies the comparator to be used. Is there less opportunity to elect representatives of their choice? Comparing it to other people who are voting. Then that brings us to the term elect. As used in this, the term must be to cast a ballot. So putting all this together, he says, the baseline is the chance enjoyed by non-minority voters to secure the election of their preferred candidates. And so what then is the chance that any given non-minority voter or group of non-minority voters has to secure the election of a preferred candidate? To answer this question depends on the voting preferences of other voters in the district. For example, in a district where most voters prefer Democrats, a Republican voter in that district will have a low chance of securing the election of his preferred candidate, because we all know, no, it's a blue state. I live in a blue state. My vote means nothing. But that chance would be substantially higher if the district were filled with voters who prefer Republican candidates. The roster of voters who end up in a given district depends in turn on the districting criteria used by the state in drawing the map. If a map is produced by computer, as is now the case today, we may think of all the parameters in the algorithm. One necessary parameter would be the number of districts required by law, and many other things. It may go on to lay out and assign priorities where permissible. You may want to minimize changes. You may want to avoid districts with discontiguous territory, avoid splitting them up. Bunch of reasons and ways that we carve the maps up. But in any event, the opportunity of these, quote, members of the electorate to contribute their votes to a winning cause is whatever opportunity results from the combination of the permissible criteria. That is what our randomly selected individual voter and group of voters can expect. And under Section 2, a minority voter is entitled to nothing less and nothing more. It's the same as every other color person. Not only is this the best reading of the law, it also ensures that the Voting Rights Act does not exceed the authority under the 15th Amendment. They have the power to enforce this by appropriate legislation, and that means effectuate it as appropriate. Our 14th and 15th Amendment jurisprudence delineates what constitutes appropriate legislation in the sense here. In legislation enforcing these amendments, we have to have congruence and proportionality between the injury and the remedy. The court has long held the 15th Amendment bars only state action that is motivated by discriminatory purpose. So a law that seeks to enforce the 15th Amendment by prohibiting mere disparate impact. So think of it differently between purpose. If you draw the maps because you want them to be racially carved up, that's different than neutrally drawing the maps that have a disparate impact. And a disparate impact would fail to enforce a right that the amendment secures. That is never appropriate because Congress cannot enforce a constitutional right by changing what the right is. And so for this reason, enforcement and focus of Section 2 must be focused on intentional racial discrimination. When Section 2 is properly interpreted in the way that we've just outlined, it is sufficiently congruent with and proportional back to the amendment's prohibition against racial discrimination. While that interpretation does not demand a finding of intentional discrimination, it does impose liability only when the circumstances give rise to a strong inference that intentional discrimination occurred. So, for example, suppose that the application of a districting algorithm yields numerous maps with districts in which members of minority groups constitute a majority, and suppose the state cannot provide a legitimate reason for rejecting all of those maps and eliminating all majority-minority districts. In that situation, the inference of racial motivation is strong, and the 15th Amendment permits the imposition of liability without demanding that you try to determine the specific intent of perhaps the hired map maker and whether that map maker was motivated by race. So it's not clear intentionality like some, Democrat named Robert Byrd, former KKK, whatever. He comes out and says something specific. That's intentionality. You can say, all right, they had a map that carved it up this way and then they reversed it all. So maybe there's an inference of racism there. That is still actionable. Only when understood this way does Section 2 of the Voting Rights properly fit within the 15th Amendment. And if you interpret it differently, if you outlaw a map solely because it fails to provide a sufficient number of majority-minority districts, that would create a right that the amendment does not protect. And such an interpretation would run headlong into the Act's express disclaimer against racial proportionality. So every race gets a specific number of seats. So properly understood, this does not intrude on the state's prerogative to draw districts based on non-racial factors. The Constitution imposes some important restrictions on the state's exercise of this power, but they're otherwise free to draw districts as they please. We've long held they may use traditional factors like compactness, contiguity, maintaining the integrity of political subdivisions, preserving existing districts, and more. Nothing in the Constitution requires the states to do that, but they can, even though some of those might not be desirable. But because they are not forbidden by the Constitution, each state can decide what they want and they can draw them accordingly. The same is true with respect to partisan advantage. You can draw politically partisan maps. That's allowed. But partisan gerrymandering claims are not justiciable in federal court. That's a political issue. Go deal with it in your legislature. Federal judges have no license to reallocate power with no plausible grant of authority to do so. So in considering these, courts must treat partisan advantage like any other race-neutral claim, a constitutionally permissible criterion that states may rely on if desired. So for this reason, as we have repeatedly made clear, when a state defends a districting scheme on the ground that it was drawn for partisan purposes, plaintiffs have a special burden to overcome. They must disentangle, to prevail, they must disentangle race from politics by proving that the former drove the lines. That means, among other things, ruling out competing explanations and other political considerations. If either politics or race could explain it, the plaintiff has not cleared that bar. Now, they may carry this burden by offering an alternative map that achieves all of the other objectives, including partisan advantage and other things, and present that. But today, Section 2 litigants almost always have the wherewithal to proffer that map if there is one to be found. We've got computer technology, there's many alternative maps and more. But in short, Section 2, says Alito, imposes liability only when the evidence supports a strong inference that the state intentionally drew its district to afford minority voters less opportunity because of their race. Not only does this interpretation follow the plain text, but it's also consistent with the 15th Amendment. Now, we also can still comply with Gingles. We're not overturning that case, but things have changed. He says vast social change has occurred throughout the country and specifically in the South. Things have changed dramatically. At the time of the Act's passage in the 1960s, the nation had faced nearly a century of entrenched racial discrimination. But the Voting Rights Act led to great strides. Voting tests were abolished, disparities in voter registrations and turnout were all erased. Black voters now participate at similar rates as the rest of the electorate, and even turning out higher in some white voters in 5 of the most recent presidential elections nationwide and Louisiana, 2 of the 5. Second, a full-blown 2-party system has also emerged. Gingles arose in the context of a 1-party system. We don't have that now. And continuing on through the Gingles analysis, he says, in that decision, in a prior decision, we also held that claims of partisan gerrymandering are not justiciable. Okay, so we don't even hear those. That's a political question, so you can't sue over that. Go complain to your legislature. And fourth, now we have computers. They draw all sorts of maps. Computer algorithms can easily control for partisan preferences and present new maps that we can analyze accordingly. And so he applies the analysis from Gingles, and he says the totality of the circumstances inquiry means we must focus on evidence that has more than a remote bearing on what the 15th Amendment prohibits. and that is present-day intentional racial discrimination about voting. He said discrimination that occurred some time ago, as well as present-day disparities that are characterized as ongoing effects of discrimination, are entitled to much less weight, and you can't use that as a justification for being racist. Nothing in Allen dictates a different result, and he continues on. In addition, our decision in Allen did not reach two pivotal issues that we now squarely address. We left open some other issues, and now we modify the interpretation of Section 2. After all of that, we still require affirmance. Louisiana's enactment of SB 8 triggered strict scrutiny because the state's goal was racial. The state never even hid the ball. It configured District 6 to achieve a black voting age population over 50% because it knew that if it didn't, the court would find the map unlawful and then require and draw their own map, which would have imperiled one of the most influential incumbents that they wanted to protect. The state's intentional compliance with the court's demands constituted an express acknowledgement. They said, well, you have to draw it. They said race played a role in our new map. Louisiana, therefore, had to satisfy the extraordinarily onerous standard of proving that its use of race was narrowly tailored to further a compelling interest. But that doesn't meet the standard. No compelling interest justifies a racist map. Section 2 does not provide a compelling interest because the state did not need to create a new majority-minority district to comply with the law. That is because at every step of the analysis, the plaintiffs failed to prove their case, saying the plaintiffs did not meet their burden because they did not provide an illustrative map that met all of the state's non-racial goals. The most obvious deficit in their maps was the failure to meet the political goals, including incumbency protection. The plaintiff's preferred map would have placed Representative Letlow in a majority Democrat district and ensured her exit from Congress. So they had a political reason for the new map that the plaintiffs could not overcome. Now, even if they had met their burden, they still would have failed to show a likelihood of intentional discrimination based on the totality of the circumstances. The Robinson court went through 9 Senate report factors. The evidence cited even showed a plausible likelihood of intentional discrimination by the state. Much of the cited evidence, like the low number of black Louisianans who have been elected to Congress in recent decades, failed to disentangle race from politics. There were perfectly political justifications for everything that they did. So they then relied on the history and saying that there used to be racism, and so now we have to fix all of that. In sum, the Voting Rights Act did not require them to create an additional black-only majority-minority district. No compelling interest justified the use of this racial consideration in the new map. That map is unconstitutional, and its use would violate the plaintiff's constitutional rights. He then goes in and obliterates Kagan and the dissenters. Said, I already addressed them. First, though, Kagan, she states over and over again that our decision requires that they prove discriminatory intent. What must be shown is exactly what the amendment called for. A plaintiff in a vote dilution case must show that the districting scheme denies members of the group the same opportunities as other voters. When that is shown, the circumstances are comparable to those in another case that we've already cited, the decision from which the new language added to Congress was even drawn. That is, the circumstances must give rise to a strong inference, so it's not intentionality, it's a strong inference. Now, second, contrary to Kagan, we have not overruled Allen. As is our general practice, the Allen court adjudicated that case based on the party's arguments. The state couldn't defend its map. Here, the state is forthright from the beginning. The aim was to protect Republican House members. One may lament partisan gerrymandering, but that's not a justification for forcing a new map. And in a racial gerrymandering case like this one, race and politics must be separated and disentangled. That is true regardless of where the case is brought, whether it's brought under the 14th Amendment or anything else. And third, this is smoking Kagan. While Kagan wraps herself in the mantle of stare decisis, which means following prior precedent, saying we don't want to overrule ourselves, we want continuity in our case law, the dissent, Kagan, is unabashedly at war with key precedents. And he cites those. He says, respect for precedent, Judge Kagan, cannot be a one-way street where you only respect the precedent that you like. He says, I'm not overturning anything here. So The judgment of the district court is affirmed. These cases are remanded for proceedings consistent with this opinion. No more racist maps. This is America. It is so ordered by Judge Alito. And a very short concurring opinion joined by Judge Thomas, a black man, with whom Justice Gorsuch, a white man, joins. It's like that meme from The Predator with Arnold and the other dude. I join the court's opinion in full. This court should never have interpreted Section 2 of the Voting Rights Act to effectively give racial groups, quote, an entitlement to roughly proportional representation. So Thomas would even go further. By doing so, the court led legislatures and courts to systematically divide the country into electoral districts along racial lines. He says blacks were drawn into black districts and given black representatives. Hispanics were drawn into Hispanic districts and given Hispanic representatives, and so on. That interpretation rendered Section 2 repugnant to any nation that strives for the ideal of a colorblind constitution. Today's decision should largely put an end to this disastrous misadventure in voting rights jurisprudence. And as I explained, says Thomas, more than 30 years ago, I would go further, and I would hold that Section 2 does not regulate districting at all. The relevant text prohibits states from imposing or applying a vote qualification, prerequisite, or standard in a manner that results in a denial or an abridgment of the right to vote based on race. How states draw district lines does not fall within any of those three categories. So I just read the law. The words in Section 2 reach only enactments that regulate citizens' access to the ballot or the processes for counting a ballot. They do not include the state's choice of one districting scheme over another. And so therefore, no Section 2 challenge to districting should ever succeed. That's from a black guy. So I don't know what Kagan's going to say about that. Probably he's not, a good representative of his ethnicity. But Kagan, we already went through her argument. She writes a big, long, whining screed. Alito already said that, she's misinterpreting his analysis, and she's going to go off into, a whiny rant that only Kagan can do. So huge victory, ultimately. And it's a big one because Barack Obama came out today. And he said this, today's Supreme Court decision effectively guts a key pillar of the Voting Rights Act, freeing state legislatures to gerrymander districts to systematically dilute and weaken the voting power of racial minorities, so long as they do so under the guise of partisanship rather than racism. But we can overcome all this. That will only happen if you cherish our democratic ideals, which means Democrat tyranny, in the upcoming midterms and whatever. So that's Obama. Tom Cotton responded. He said, Obama has supported and campaigned. He literally was making videos for Virginia's redistricting for every outrageous Democratic gerrymander, including in Illinois. Have you seen those maps, by the way? Illinois maps are crazy. But now he puts out a sanctimonious statement when the Supreme Court rightfully blocks racial discrimination in redistricting. What a fraud. Thank you, Tom Cotton. He's absolutely right. And Hakeem was out, and they went, and I think they went through Congress, and they just got like every black person that they could find. They're like, oh, you're black. Hey, come out here. Hey, you're black. Hey, come out here. Hey, come out here. This is racism against us. I think they just brought them all out here. And then they did a little press briefing, and he said something like, this isn't even the Roberts court. This is the Trump court. And what we would expect from the Trump court is an effort to continue their scheme to suppress the vote and rig the midterm elections and beyond. It's a racist map. They're saying that all black people are the same, and they're putting them into certain categories. We don't think that's true. Apparently he does, and so does Barack Obama. But Clarence Thomas doesn't agree with you, Hakeem. And so what do you think about that? So Ron DeSantis also came out. He said, the SCOTUS ruling also invalidates the below provisions of the Florida Constitution, requiring the use of race in redistricting. It was in their constitution. He quoted it. He said, districts shall not be drawn with the intent or result of denying or abridging the equal opportunity of racial or language minorities to participate in the political process or to diminish their ability to elect representatives of their choice. So they actually included that in the consideration. And Ron DeSantis is in the middle of a redistricting fight, presumably coming soon, making its way through the Florida legislature. Harmeet Dillon said, extremely gratified to see and she's not a white man, to see this decision we've been waiting for. I was proud to co-author the brief for the United States as amicus in this important case, perhaps one of the most important developments in decades in Voting Rights Act jurisprudence. That's from Harmeet. We had the governor, Landry, from Louisiana. He said, the Supreme Court has affirmed what we have said for years. Drawing districts for political reasons is the state's prerogative, not a federal civil rights violation. Federal judges cannot force a state to engage in race-based redistricting, and plaintiffs can no longer repackage partisan disagreements as Voting Rights Act cases in order to force districts to draw racialized districts. Now, we also saw that today there was a separate set of Supreme Court oral arguments, and Alito was out. Eric Dougherty clipped this one for us. He captured this exchange in a battle over race, really. Supreme Court oral arguments, we had an attorney for Haitian nationals, this guy right here, who looks like the appropriate attorney for them. He was getting into it with Alito about the various different racial groups and how you would harmonize and dictate who's white and who's this and who's that. And how do you carve everybody up? It's very complicated, which is why we don't do that in America. Here's this attorney versus Judge Alito.
The government action. The Arlington Heights framework exists precisely for the purpose of sussing out whether impermissible racial considerations were were impermissibly in the mix.
Isn't it the case that TPS was terminated for quite a list of countries? I can't seem to find the particular page of the transcript where the district court goes through them all. And yes, none of those is a Nordic country. And I don't like dividing up the people of the world arbitrarily into three racial groups. But you say they're all non-white, and that's the distinguishing characteristic.
That is the distinguishing characteristic that the district court held. But I would emphasize, Justice Alito, that.
But do you think that if you put Syrians, Turks, Greeks, and other people who live around the Mediterranean in a lineup, do you think you could say those people are that all of them, are they all non-white?
I understand that Syrians, I think, may be classified as white for purposes of the State Department, or for under certain government programs. But again, I think race is, I think, you'd have to poll the public to know what they think the race of a Syrian is. I certainly think they're not white.
Poll the American people?
Well,
do they think Syrians are white?
I wouldn't think that most would, Justice Alito.
Really?
I really don't.
How about Turks?
I honestly haven't considered what racial component I would sort Turks into.
How about Greeks?
I don't know the answer to that either.
How about Southern Italians?
Well, certainly 120 years ago, when we had our last wave of European immigration, Southern Italians were not considered white. So I think our concept of these things evolves over time.
How about Spaniards?
I think same answer. About 120 years ago, I don't think they were considered white.
You have a really large, you have a really broad definition of who's white and who's not white. As I said, I don't like dividing the people of the world into these groups.
I understand. I would say that even under this court's rationality jurisprudence, if you look at cases like Moreno, it is not necessary for us to get strict scrutiny to win here, because irrespective of how you do the classification at issue here, under those courts, under those decisions, under those precedents, bare dislike of an unpopular group is a sufficient basis to find that rational basis is not even satisfied.
Yeah, so very complicated, carving people up into different racial groups, and not a real good answer. It's kind of, you're white if we don't like you, and if we want to, give you unlimited TPS into the United States, then we'll call you something different. Obviously, we don't want more of that in America, in spite of the Democrats' best efforts to make it all about that, because they have to carve people up into various constituencies and conglomerates in order to cobble all of the constituencies together to win elections, which is why they just keep pumping it all the time on without any end in sight. Now, in Georgia, a state that is going to be impacted by this brand new Supreme Court 6-3 decision, Greg Dolezal, who's in the Congress right now in their legislature, he said, it's time to call a special session in Georgia. Now is not the time for Republicans to be weak-kneed. It's time to be bold. Call for special sessions, redraw the unconstitutional congressional maps in the South, and stop the racial discrimination and the racial gerrymandering that has been in place for 30 years. Here's Greg Dolezal.
All right, y'all, the Supreme Court just told us what we all already know to be true. Racially gerrymandered maps are unconstitutional. So it's time for Georgia and other southern states to remove these maps that we drew that were unconstitutional. You know, we look in the Northeast and we see what Democrats have done. Connecticut, Maine, Massachusetts, Rhode Island. They've completely removed every single Republican congressional seat. The last thing that Republicans need to do is be weak-kneed in this moment. This is a time to be bold. This is a time to be aggressive. And in Georgia, that means calling a special session and redrawing our maps.
Let's go. And he's running for lieutenant governor. So if you're out there in Georgia, Greg might be your guy. Now, Trump was asked about this, very short clip today. He was hanging out with the NASA crew, and they asked him specifically, hey, what do you think about this new decision? And he wasn't too up to speed on it, but here's what he had to say.
Thank you very much, Mr. President. I want to go back to the Supreme Court ruling on the Voting Rights Act. I know you said you haven't seen it.
When did it come out? Just now?
No, it came out this morning, but basically very much narrows the Voting Rights Act.
Was it considered a win for
a win for Republicans?
I love it.
But my question,
This is a very good. We can end this conversation. I want to read it.
My question for you, Mr. President.
I love it. We love it too, Mr. President. We don't want racism in America. And that is, of course, what the original 15th Amendment, what the Voting Rights Act was for. The Democrats for years have been able to invert it, essentially, to say that if you don't give us this, then you're a racist. And you have to give us equal outcome rather than equal opportunity. Not anymore. Justice Alito giving us the right decision in a very brilliantly, methodically crafted decision. 6-3. No more racial gerrymandering in America. So we're going to see what the reaction is to this, how the states now interpret this and enforce it, and maybe adjust the maps to get rid of this vestige of discrimination that should no longer be in our politics. We'll keep our eye on all of these developments and more. Thank you for subscribing and joining as we do. All right, now we're not done yet. We got two great segments that are coming up, starting with this new detention order, which is a big one. New evidence in the Trump attacker case. We're now seeing the DOJ file a motion to detain Cole Thomas Allen, the guy who went into the White House Correspondents' Dinner and tried to race through Secret Service agents and attack and maybe even kill President Trump, according to his manifesto. In the District of Columbia, we see the DOJ submitted this filing today. They say the United States and the D.C. U.S. Attorney are now submitting this memo in support of their oral motion to detain Cole Thomas Allen pending trial. And we've got new evidence in this one because they even share with us photographs of the weapons and this selfie that the guy took right before he went on his suicidal spree. Here's what they explain. They say the defendant attempted to kill the president, Donald J. Trump. The crimes with which he is charged are among the most serious in our law, and the evidence of his guilt is overwhelming. He faces a possible sentence of life in prison and a mandatory minimum sentences of 10 years if he's convicted, and that's going to be consecutive to any other sentences if they're imposed. This was a premeditated, violent, and calculated effort to cause death. So considering all of these factors, there is no condition, there's no combination of conditions that will reasonably assure the safety of other people or the community if he is released from custody. We cannot allow that to happen, and he should be detained pending trial. Background on the matter, as we know. Shortly after 8:30 p.m. on April 25th, Secret Service personnel engaged and stopped Cole Allen. He was armed with a 12-gauge pump-action shotgun, a .38 caliber pistol, multiple knives and daggers, and a significant amount of ammunition for reloading. As he sprinted toward the doors of the Washington Hilton Ballroom hosting attendees at the White House Correspondents' Dinner, including the president and many of his top administration officials. He was arrested on scene, and on April 27th, he was charged with violating multiple U.S. code. attempting to assassinate the president, and transportation of a firearm and discharging of a firearm during a crime of violence. He made his initial appearance the same day, and he was held pending a detention hearing scheduled for April 30th coming up. Now, the White House dinner is an annual event, dates back more than a century, typically held at the Washington Hilton Hotel. On many occasions, the president has attended. In this year, it took place on April 25th. Trump, Melania, JD, and approximately 12 members of the cabinet, which is a big number, all were there. The dinner's main program commenced at 8 p.m. and shortly thereafter, the president and other high-ranking officials took their seats on a raised dais inside the ballroom. The event was broadcast on national TV. Shortly after 8:30, Cole Allen approached the Secret Service security screening checkpoint near the terrace level of the hotel. Entrances to the ballroom were located on the concourse level, a floor below the screening checkpoint, down to 2 open flights of stairs. Before he approached the checkpoint, he discarded a long black coat that concealed the 12-gauge pump-action shotgun. He then sprinted through one of the magnetometers at the checkpoint and ran in the direction of the stairs leading to the ballroom where Trump and his family and his cabinet were all located. As he did this, he held the shotgun in both hands in a raised position parallel to the ground. Secret Service officer observed Cole fire the shotgun in the direction of the stairs leading down the ballroom. The officer and others at the checkpoint heard the gunshot. The officer then drew his weapon and fired 5 times at him. The defendant fell to the ground, was restrained by law enforcement, and was placed under arrest. He suffered a minor injury to his knee, but he was not shot. At the time of his arrest, he was in possession of a Mossberg 12-gauge pump-action shotgun with 1 spent cartridge in the barrel and 8 unfired cartridges in the magazine tube. An additional 6 unfired cartridges were attached with Velcro to the shotgun in a detachable ammo carrier, and he possessed another 10 unfired cartridges in a small leather bag. He was also in possession of a Rock Island Armory 1911 38 caliber pistol with 10 rounds of ammo. He also had 2 additional handgun magazines, each containing 9 rounds of ammo. California and federal database records confirm that he legally purchased the 2 weapons from separate dealers in California, buying the shotgun August 17th, 25, the pistol October 6, 23. At the time of his arrest, he also had on his person 2 knives, 4 daggers, multiple sheaths, multiple holsters, needle nose pliers, wire cutters, and a Samsung cell phone. Now, after the attack, law enforcement executed a search warrant on his hotel room. They recovered, among other evidence, 2 additional knives, a magazine, 10 rounds ammo, 2 boxes, each containing 10 rounds of shotgun ammo, a half face piece respirator, a roll of duct tape, 2 rolls of grip tape. In addition, law enforcement conducted a search of his parents' residence outside LA, where he lived. In a bedroom belonging to him, he lived with his parents. Law enforcement recovered 2 long gun bags, a Mossberg buttstock, a pistol holster, and a training pistol. The photographs below show some of the weapons and the accessories that he possessed when he was arrested. There's the shotgun. There's the 1911. He also had several electronic devices. Here are all the daggers. Like, what does he think he's going to do with all these daggers? Do you need all of those? 6 of them? So he's got 6 of them, it looks like, in this photo. Multiple variations of this one. Is he throwing these? Then he's got wire cutters and needle nose pliers along with the holster. Now, at some point before the attack, this guy wrote emails explaining the actions he was about to take, and he scheduled those emails to be sent to specific people at 8:30, just minutes before he, laden with weapons, sprinted through the screening checkpoint towards the dinner. The email recipients included members of his family, friends, and former employer. The email to family members stated, "I wish I could have said anything earlier, but doing so would have made none of this possible. My sincerest apologies for all the trouble I've caused. Scheduled send, signed Cole." The email to the former employer also stated, among other things, "I'll include the full text as an attachment, but I do specifically want to apologize for the unprofessionality of this. Consider me to be submitting my resignation effective immediately." Attached to the emails was a text file titled Apology and Explanation. This is his manifesto. We have read this before. And apologies. I can't allow a PDF file, an R, and a traitor. We all got that. He goes through his targets, as we've seen. This is his manifesto. He wanted everybody, but not Kash Patel, which is always kind of a weird little anomaly there. And he's going to be using buckshot rather than slugs, so he doesn't kill people. So his apology letter also included a list of hypothetical objections to his plan to kill the president and other senior officials. One of his hypotheticals was, you didn't get them all. He said, well, you got to start somewhere. He said another objection was, yield unto Caesar what is Caesar's. In response, he said, well, America is ruled by the law, not by anyone or several people. Insofar as representatives and judges do not follow the law, no one is required to yield them anything so unlawfully ordered. In a postscript in his letter, apparently written inside the Hilton after he arrived and after he saw security measures and made observations, he ranted and his words and described what he viewed as deficiencies in security. He wrote that he walked in with multiple weapons. Not a single person considered him to be a threat. He went on to complain, if I was an Iranian agent instead of an American citizen, I could have brought a damn Madus, which is a nickname for an M2 50 caliber Browning heavy machine gun. He signed his letter, Cold Force Friendly Federal Assassin Allen, and at the end of the letter described how he felt awful about what he was about to do and that he experienced rage thinking about everything this administration has done. Then he said, can't really recommend it. Stay in school, kids, like an insane person. Now, although just days old, the investigation of his assassination attempt has yielded significant evidence of his extensive planning and preparation. On March 2nd, Trump publicly announced that he would go to the dinner. He posted on his Truth Social, saying, they've asked me to come, and I'm happy to do it to be the honoree. He also added that it would be his honor to accept the invitation. That March 2nd post was publicized across multiple media outlets. A little over a month later, on April 6th at 2 p.m., he used his cell phone to search White House Correspondents' Dinner 2026, used an online search engine, and visited the webpage for the event. Less than 2 hours later, at 3:28, he received a confirmation email for a 2-night stay at the Hilton. So he says, oh, Trump's going. When is it? Perfect. Books the hotel. 10 days later, on April 16th, he used his cell phone to access a series of online media articles discussing the dinner, including its host, the event schedule, and the expected attendees. At some point on April 21, he purchased a one-way Amtrak train ticket from LA, California to DC via Chicago. On April 21, he used a rideshare app to travel from his home to LA to Union Station, boarded a long-distance Amtrak passenger train to Chicago, a route famous for its scenic views of mountains and deserts of the American West, before traversing the Great Plains. While en route, on April 22nd, he used his cell phone to view a news article titled, Trump's Plans for Mic Drop Media Confrontation Are Leaked. The president is planning a rage fuel moment at the dinner. He arrived in Chicago the afternoon of April 23rd. A few hours later, he boarded a second train to D.C., this time passing through the Great Lakes and the Appalachia regions. While en route from Chicago to D.C., he again got on his cell phone, went to a D.C. newspaper, viewed an article entitled Social Scene, Your Guide to the 2026 Correspondent Dinner Weekend. He also kept a running note on his phone of his observations and thought during his cross-country train journey. He wrote, the Southwest desert in the spring, distant wind turbines looming like snowy mountains across the hazy New Mexico desert. Okay, beautiful poetry. Chicago is cool, kind of like an Iowa small town was scaled to LA size. And that Pennsylvania's woods are awesome. Looks like vast fairylands filled with tiny trickling creeks in spring, apparently. He then arrived in D.C., 1:10 p.m. on Friday, April 24th. Approximately 30 minutes later, he purchased a Metro smart card with a 3-day bus rail pass, traveled by Metro train to Union Station to DuPont Circle, and checked into the Hilton. The next day, April 25th, the night of the dinner. On that day, he left his room multiple times. During one occasion on April 25th at 6:26, he left his hotel room for approximately 20 minutes. During that time, got on his cell phone and looked at the presidential schedule on civictracker.us. Then at 8:03, while back inside the hotel room, he used his cell phone to take a photograph of himself in the mirror. In the photograph, the defendant was wearing a black dress shirt, black slacks, and what appears to be a red necktie, which is kind of Trump's signature, tucked into his pants. And An enhanced version of the image below to the right shows that he appeared to be wearing a small leather bag consistent in appearance with the ammo-filled bag that was later recovered from his person. There was also a shoulder holster, a sheathed knife, consistent with the appearance with one of the knives that was recovered from his person. Pliers and wire cutters consistent in appearance with those later recovered. All seen here. Ammo bag, holster, sheathed knife, gun up here, taking a selfie of himself. And there's a lot of memes going around with this one right here, like in the TV shows, like Record Scratch. Eric, you might be wondering how I got here before I went on a suicide mission. The story's something you're never going to believe. One of those. So about 10 minutes later at 8:13, he again visited the Civic Tracker website. Then 2 minutes later, he left the hotel room. At 8:27, just minutes before the attack, he used his cell phone to go to a website and access the video. Watch live, Trump First Lady en route to the dinner. He visited another website to view live media coverage of the president exiting the vehicle to go into the building. Less than 1 minute later, he searched Trump White House Correspondents' Dinner on a web search engine. He then sent pre-scheduled emails with the apology and explanation sent a few minutes later at 8:30. Shortly thereafter, he rushed the screening checkpoint on the terrace level of the Hilton with a raised shotgun. So now the government says, we got to detain this dude. He's charged with attempted assassination and hopefully our internet picks back up. He's charged with pretrial detention under 18 U.S. code, and he's charged with attempted assassination in violation of another code. This is a crime of violence and an enumerated federal crime of terrorism. He's also charged with discharging a firearm during this and is charged with transporting firearms across state lines. Upon a finding of probable cause, the federal statutes create a presumption here, far exceeds probable cause, and the federal bail statute creates a rebuttable presumption that the defendant would pose an intolerable risk of danger. Together with the presumption of detention, the court must consider the nature and the circumstances of this event. And all of these show he should be detained. He's charged with traversing the country armed to the teeth, rushing through Secret Service with a 12-gauge shotgun to try to kill Trump. Yet those crimes, as heinous, as infamous as they are, do not fully capture the plan. He was willing to commit a mass shooting inside of a room full of the highest-ranking U.S. officials. Worse still, although he articulated his own disconcerting rules of engagement, he noted that every attendee of the dinner was acceptable collateral damage merely because they chose to attend an event where Trump would speak. He did all of this for the purpose of engaging in an act of political violence, and all of this weighs in favor dramatically of pretrial detention. Now, his choice of targets demonstrates the deeply dangerous nature of his conduct. Attempted murder is always a serious crime, but when the intended victim is the president, the consequences are far-reaching. Had he successfully entered the ballroom, he not only could have killed or injured dozens, and he could have destabilized the entire federal government, given the number of high-ranking officials that were there. He sought to express his political opinions through violence. The court should consider the identities of the victims and the role they play in this attack. Now, his crimes were also premeditated and calculated to achieve his objectives. Leading up to the night of April 25th, he was premeditating and planning this whole thing. He started it back in LA, got on a train, transported an armament across the country, and then his internet history also shows how premeditated this was. He was using open source media to track the president and was waiting for them to arrive. He was stopped only because of the brave actions of law enforcement officials, and he was willing to harm everybody, even though he wrote differently in his rules of engagement. In his own words, he viewed anyone there as being a legitimate target because they came to hear Trump. This is a callous disregard for human life and a willingness to harm others, even though they were not his political targets at the time. So at the root, these were acts of extreme political violence. While the investigation is still in its nascent stage, the evidence collected thus far shows that he sought to kill the president because he disagreed with him politically and wanted to fight back. He found policies morally objectionable. The nature of his crimes further counsels in favor of detention because his motivation for committing these crimes continues. So long as the president and the others appear publicly, he is going to continue to want to do this. Now, in his own words, he believes that reps and judges don't follow the law, and thus he does not believe he's bound to follow the law either. This type of justification for political violence is especially dangerous because it is without bounds. In his view, he is the ultimate arbiter of political and legal authority, and he's not bound by any law. All of this can be used as justification to kill. Now, ultimately, he failed to accomplish his goals. It is extraordinarily good fortune that no one was seriously injured or killed, but that doesn't diminish the seriousness of his crimes. If he's convicted, he faces life imprisonment and a mandatory minimum of 10 years. And so the weight of the evidence against him is strong. Overwhelming evidence saying he's going to very likely be convicted. And although apparently he has no prior contact with the criminal justice system, his personal history and circumstances demonstrate that conditions less restrictive will not assure the community's safety. He's highly educated, and until shortly before the events of April 25th, he was employed and living with his family in California. Despite this stability, he chose to embark on a journey that culminated in this violent attack. He also was able to deceive his family and travel to D.C. with his weapons by train without detection. So he's demonstrated not only a capacity to accumulate and use significant amounts of lethal weaponry, but also a willingness to deceive those closest to him in order to achieve his goals. And when this is something that comes up, it is indicative that he may do this again in the future. And so he is a danger to the community. He traveled across the country, wanted to kill the nation's most senior leaders. He intended to kill, fired his shotgun while trying to breach security. Put simply, he poses an uncommonly serious danger to the community if he's released. His lack of criminal history and other personal circumstances does not alter this. And the community should not be subjected to the prospective articulable threat that he will reject this court's legitimacy, as he's articulated he does, and rejected the legitimacy of the U.S. government, and that he's likely to register his political disagreement with violence. And so there is no combination of conditions that will reasonably assure the community's safety if he is released, and he should be detained pending trial in this case. All respectfully submitted, courtesy of D.C. prosecutors. You know both of these names. These are the same prosecutors who are on the pipe bomber case, Charles Jones and Jocelyn Ballentine, also prosecuting Brian Cole, similar name there. And so DOJ, I think, obviously has a very good argument for this. I have my doubts that the judge will let him out at all, but we'll see what his defense team says. And the judge just today has now permitted legal visits as to him. So he's going to be meeting with his attorneys. They'll, of course, file their response, and we'll see what the judge does on this one. But I think much like the other pipe bomber, alleged pipe bomber, they're not going to let him out. Judge is currently Matthew Sharbaugh. And so we'll see what else happens on this one, but he'll have a detention hearing at some point, and the judge will decide whether to release him or not. And so we're going to keep our eyes on this one. Thank you for subscribing and joining as we do. All right, my friends, we got one final update on the day, and then we'll see what you have to say about all of this and more. James Comey surrenders under federal charges, turns himself over to the court, and we're waiting to see exactly what comes next in this case after he's been indicted for his 8647 Seashell by the Seashore saga. CNN always gets these leaks. I think they've got a bunch of sources inside the FBI, and probably James Comey's lawyers are feeding them info. But they reported that today he did appear in a different court, not the court where he was charged, but he did self-surrender is what this sounds like. So no 4 a.m. raids with dozens of FBI agents kicking the doors in like they did for Roger Stone or for many of the other J6ers. Turned himself in before federal court in the Eastern District before his first appearance in the Eastern District of Virginia. Comey is charged with making threats against the president for photographing the seashells or maybe writing them down. He was allowed to leave court with no conditions of release after a brief hearing that lasted less than 10 minutes. So is he having to post a bond? No. Is he on pretrial services? Does he have to check in with somebody? No. Does he have to give up his weapons? No. I don't see why they'd be necessary at this time, said Judge William Fitzpatrick, noting that there were no conditions set when the Justice Department first attempted to bring a case against Comey last year. Yeah, but the charges are different this time there, Judge. That set of charges was about lying to Congress. This is about threats to kill the president. Comey's latest indictment came Tuesday, came from acting AG Todd Blanche. The new case is a reinvigorated case, and Comey's whining about it. Now charged with making a threat. The charges were brought in Eastern District of North Carolina, but his first appearance was in Alexandria, Virginia, because that's closer to his home. So also very convenient for him. They didn't arrest him and haul him in to North Carolina. They just said, come turn yourself in here in Alexandria. We'll give you a nice little red carpet for you, too. On Tuesday, Comey entered and exited the courtroom through a side entrance used by defendants. He wore a dark suit and did not speak during the hearing. He was not asked to enter a plea. His lawyer said that we're going to be filing motions saying that he's being selectively and vindictively prosecuted. No date has been set for the arraignment in North Carolina. And the case was brought by W. Ellis Boyle. We heard from him on yesterday's show, who will be overseeing this case when it moves back over to North Carolina. We know that he posted 8647, and he probably did it to pump up his book sales, knowing that it was a threat that is very similar to the plot line of his new novel. This is the second time that he's been charged. Last time, the case never went further and reached the merits because they disqualified Lindsay Halligan, but he is now self-surrendered, so no 2 a.m., 3 a.m., 4 a.m. raids for the former FBI director. And we're refreshing this to see if anything else has hit the docket. Doesn't look like anything has hit the docket in the actual matter. So he just made his surrender, so you can't expect any arrests happening. Here's what CNN was reporting. It looks like they had somebody outside the courtroom there in Alexandria, and this is how it went down this afternoon.
Well, Comey is in the courtroom, and the hearing is starting now, the very first appearance of this former FBI director accused of threatening the president's life with that post on Instagram a year ago with seashells in the sand.
Weird way to say that.
This is the first hearing that will happen in this courthouse, the Eastern District of Virginia, but this is a case that's charged in North Carolina because that's where that beach photo was taken. This first appearance, Comey now being under arrest in the courtroom. He's going to be before a
All right, so he was in front of the judge. They reported on the rest of it. Stephen Chung at the White House said, this was a masterclass interview from Todd Blanche. He obliterates these ridiculous questions. And so Todd, after announcing the charges yesterday, hopped on with CBS Morning. And this is what he said earlier today, courtesy of CBS. James Comey made his little apology video. And here's Todd Blanche getting into it, defending the nature of the proceedings.
The grand jury indicted Mr. Comey yesterday. Grand juries hear evidence. That evidence is not something that anybody can talk about today. But when you talk about whether proof exists, the proof that we have is in the fact that the grand jury returned an indictment. Remember, that is not the Department of Justice charging James Comey with a crime. That is a grand jury returning a 2-count indictment.
Let's do a compare and contrast, Mr. Blanche. In 2022, someone well-known in right-wing circles, Jack Posobiec, posted on X, 8646. He did not take it down. He did not apologize. Mr. Comey has done both of those things. The Biden Justice Department never prosecuted him. By the standard of that grand jury, Jack Posobiec should face charges as well. Will the Justice Department pursue that case? Because they sound very similar.
That's just completely not true. That's not how a grand jury does its work. They don't just look at a single image and then say, okay, yes, we'll indict, or okay, no, we won't indict. They do an investigation. This conduct took place in May of last year, May 15th. It has been almost a year. I assure you, the FBI, the Secret Service, and the U.S. Attorney's Office have not been sitting around doing nothing. They have been investigating. I have no idea whether there was an investigation into the other times that post has been made and whether that investigation yielded different results. This investigation that we undertook resulted in a 2-count indictment. So you cannot compare, well, what happened last time, what happened this time. Every investigation is different. You know that. The American people know that. A lot of factors go into whether somebody should or should not be charged. The mere fact that there's a similar photo posted or similar statement made, that's true every day. There's comments made about President Trump, threats made against President Trump. Every one of those are not indicted. It depends on the facts of every case.
Mr. Blanche, you lived this history much more than I did, but I'm going to paraphrase what you said about the hush money case that was brought in New York. You said at the time, supposedly serious people were bringing unserious charges and warping the language and the facts and the law because there was a political imperative beyond that. Are you telling the American people this morning that this is a serious case and this is a serious set of charges and that laws and facts are not being warped to carry out a political agenda?
Look at the indictment. That's not for me to decide. That's for the American people to decide. And if anybody in this country thinks, especially what happened over the past couple years with respect to President Trump, that it is okay.
I'm sorry about that.
Threats made.
It's warped to carry.
That happened over the past couple years with respect to President Trump, that it is okay for anybody to threaten the President of the United States, that it is okay to threaten the President of the United States and then have the media or others say, well, that's not serious, then we have a bigger problem than I even imagined in this country. Of course it's serious when you threaten the President of the United States, and anybody that tries to put forward some narrative that this is just about seashells or something to the contrary is missing the point. You cannot threaten the President of the United States. That's not my decision. That's Congress's decision in a law that they passed. And so, yes, of course this is a serious case.
Mr. Blanche, did the President of the United States in any way direct you to pursue this matter?
Of course not. Absolutely, positively not. And there's no suggestion that that's the case that happened. And the fact that we're doing our work, this is not something that just happened the past couple of weeks. This is something that has been investigated for nearly a year now. And the results of that investigation is a grand jury returned an indictment.
Critics of you and this administration, Mr. Blanche, have suggested this is an audition to become the nominee to be Attorney General. Is it?
I don't even know what that means. We work hard every single day. The Department of Justice returns over 100 indictments across this country every single day, making this country safe. And so this narrative, this idea out there that somehow I'm auditioning, I've worked with President Trump for many, many years. I don't audition for this job. I've been the Deputy Attorney General for over a year. Okay, this is not an audition.
And you are confident this case will result in a conviction?
I do not comment on convictions, and no prosecutor ever should. What I'm confident about is that there's been a 2-count indictment returned, and Mr. Comey will get his day in court.
Todd Blanche, Acting Attorney General.
Nice. All right, so Todd Blanche out there pushing back against the media narrative that this is all political. The grand jury didn't seem to think that. And here's more from John Kennedy. Senator Kennedy said, you know, James Comey is too immature to ever be given power. The best job for him would be trying to work his way up into management at Panda Express, getting some of that orange chicken, too. That's where he could do the least amount of harm. Here was Kennedy talking about this earlier today.
I do have, unfortunately, a lot of experience with Mr. Comey. Mr. Comey is one of those individuals, while smart, is too immature to be given power. Again, I'm not saying he's not smart, but he's too cute by half. And he thinks he's smarter and more virtuous than everybody else. Probably, given his personality and his lack of morals, the best job for Mr. Comey would be to go to work for Panda Express and let him try to work his way up into management. He could probably do the least amount of harm there.
And he get 86 orders, too.
Who should ever be given power. I do have
86 all those orders when the DoorDash driver doesn't get up. Maybe that's more appropriate for him. So Trump was asked about this in the White House today, courtesy of Caitlin Collins. And here's what he said in response to Comey's new indictment.
We were talking about how busy you were this morning. James Comey was in court. He self-surrendered. He's now been charged a second time, this time over a social media post with seashells that said 8647. Do you really think that he was endangering your life or threatening your life with that?
Well, if anybody knows anything about crime, they know 86. You know what 86? It's a mob term for kill him. You know? You ever see the movies? 86 him. The mobster says to one of his wonderful associates, 86 him. That means kill him. It's, I think of it as a mob term. I don't know, people think of it as something having to do with disappearing, but the mob uses that term to say when they want to kill somebody, they say, 86, the son of a gun. I'm trying to keep the language nice and clear. They don't use that term, son of a gun. They use another term. But that's a mob term for kill him. Yeah.
But do you really think your life was in danger?
Probably. I don't know. You know, based on what I'm seeing out there, yeah. The people like Comey have created tremendous danger, I think, for politicians and others. Comey is a dirty cop. He's a very dirty cop. He cheated on the elections. He tried to help Hillary Clinton, as you know. He dismissed a lot of things that he should have proceeded with.
Yep.
I wasn't involved, but he should have proceeded with. No, he's a dirty cop. He's a crooked man.
That's exactly right. So, Mr. President, thank you for that. And the Comey prosecution will continue on. Looks like the docket has not been updated any further, but we do know self-surrender today. No FBI agents willing to, I guess, go and raid his house, but for everybody else, they're happy to do that. So we're, of course, going to keep our eye on this one. We'll see what the next filings entail. Thank you for subscribing and joining as we do. All right, friends, it has been a beautiful stream. Sorry for some of the internet hiccups today. We'll be back in our home base tomorrow, and then it should be smooth sailing from there. But if you're just joining us, quick recap. We had a great update on the Supreme Court case, Louisiana versus Calais, saying in a 6-3 decision that racial gerrymandering is unconstitutional for the most part, and you're not allowed to do it. So we'll, of course, see what the reaction is. We saw that there was a lot of outrage here from Nancy Pelosi, from Barack Obama, from Hakeem Jeffries. We read through the decision, got some briefings on the dissent arguments, and heard from Clarence Thomas, who actually is saying this didn't even go far enough. So we'll see exactly what else comes down the line here. We then turned our attention to Cole Allen Thomas and his new selfie photos that he took of himself just minutes before he went on his suicide mission to attempt to kill the president, another one of them. He had knives, guns. He had a bunch of self notes that he wrote in his smartphone. Took a trip from LA to Chicago, then over to DC. Didn't tell his family about it. Sent some resignation letters into his presumably school. And now the DOJ is saying, do not let this guy out of detention. Keep him in custody pending the trial. Then lastly, we learn James Comey self-surrendered and turned himself into the court, did not get raided. And we'll have more updates here as soon as the docket populates. But Trump responding to this, Todd Blanche responding to it, saying the grand jury indicted him, not us. So the evidence that they presented to them made enough sense to them to think that there was enough evidence of a crime here such that they charged him and issued an arrest warrant for him. So all good updates. And now, my friends, it's time to hear from you. Thank you for being here and thank you for joining us. And I want to say thank you so much to those of you who donated yesterday. So we have our ericshouse.org annual fundraiser happening all this week. And then we're having our big event this Saturday. It's going to be on May 2nd, 12 o'clock Eastern time. We'd love to have you join us. If you're not familiar with ericshouse.org, it's a nonprofit that's set up to help people who've lost someone due to suicide, overdose, or tragic death. That's something that hit my family very hard. We lost my brother, Eric, to suicide after he had a struggle with drugs. He had a broken wrist. He had multiple surgeries on his wrist. That led to them prescribing him the opioids. They just handed them out like Skittles back then. That turned into a heroin problem, and then he was dead a short time later. So it's a horrific thing. And what our family has found is that in the aftermath of a tragic loss like that, whether it's suicide, overdose, or tragic death, families really don't have anywhere to go. And we have a men's group at Eric's house. We have all sorts of various groups out there that are set up to help people who are going through that, like a triage team. So as soon as the loss happens, you can get loved up. You can get some support because we didn't find a lot of that when we were going through our experience. And it's a horrific thing. I mean, tragic death, like a father, who's on an ATV with his 12-year-old, something, freak accident happens. 12-year-old has his neck and he's dead. So what do you do? How do you deal with that grief? And Eric's house is set up literally for that. And so yesterday I shared this with you guys and I was just blown away by the support. We're going to do a full debrief tomorrow, but you can see we started a Watching the Watchers team on this, and we have had so many just incredible donations that came in. You can see a ton of them coming in from all over the place. And I want to pay proper thank yous when our internet is not cutting in and out. And so I want to save this for tomorrow. I want to come back and thank every single person who sent donations in tomorrow. And we got a lot of them. And we're just really grateful for it because all of this money goes to care. It goes to the continuity of ericshouse.org. And my mom set all of this up, trying to turn a horrific situation for her family into something positive that she can pay forward. And they've done just an amazing job. So Saturday, we're going to have the full event. We're going to do a live stream. Your boy's going to be hosting it. They've been working on this week, the final touches on the presentation. And you'll learn a lot more about it. You'll get to hear from other survivors who've gone through these losses. And we're trying to make some money, really. It's a 501c3 nonprofit, so all donations are completely tax deductible. And you can see there are a ton of groups here. That's my mom, that's Greg, Men's Org, Stu's Hairdos, the Watching the Watcher fam has really shown up. Thank you guys. We got 10 supporters in the house, and we're raising some money, and we appreciate it. We're just super grateful for it. So I want to come back tomorrow and make sure we give everybody a proper thank you and make sure we read through all of these at the close of the show. So if you're intending to support us, support the show with any super chats or anything like that, we would just ask you send it on over to Eric's house. They're going to do something much better with it than we would here. So thank you once again. The links are in the description below. We're grateful for you. We love our Watcher fam. You guys are showing up and we're so grateful for it. We've gotten some really nice emails too. So thank you, thank you, thank you. Tomorrow we'll have proper thank yous when we're not cutting in and out. And thanks again for considering it, because it's for a good cause. And unfortunately, there are a lot of families out there that don't know what to do. After something like this happens, it's like a bomb goes off. I can speak from experience on that. And it led to, some difficulties for me. It led to my alcoholism, which was already in second gear, going into fourth gear. And it was a real problem. So I'm grateful for the support. I'm grateful for the love. And we're grateful for you. Thank you for checking out the link and supporting ericshouse.org. And Saturday, hopefully you come and join us 12 o'clock Eastern, because we're going to have a mega stream. I think a 3-hour stream or so. We're going to hear from the men's group. We're going to hear from people in person. It's going to be beautiful. So thanks for checking that out. It's our annual fundraiser. We love you. All right, here, my friends. And now it's time to hear from you. So thank you for sending these in. Oh, it's James Comey. Oh, he's in prison. He found some seashells on the prison floor. It says, crap. Oh, they're honey buns. They're not seashells. There's no seashells in prison. They're honey buns. He had to do something to get all those honey buns, man. You don't just get those easily in prison. So I don't know what he had to do to get those, but there's James Comey. Oh, he's working on his next novel. Isn't that fun? Hey, Ospac, what's up? Hey, sorry, in case you missed it, sorry for the dupe if already posted, but Fox News claiming, I did see this, yeah, that the people who assaulted the TPUSA reporter, Sarah Hernandez, has now been indicted. So 2 people indicted on federal charges. That's good news because she was victimized. And we're happy to see justice is out there. Ospac, thanks for being on Locals. Thanks for the dono. Hey, Mr. Don from yesterday, had to watch it today. The UK still has a king because if we had an elected president, we'd end up with people like Biden. Yeah, that's not, we wouldn't wish that on anybody, even our friends in the UK. Thank you, Mr. Don. Yeah, and he was there yesterday, apparently. Did you guys see that bee photo with the president, like looking at the bee, and Melania and the king are like, oh, it's going to sting you. Trump's like, nothing stings me. Great photo. Thank you, Mr. Don. Thanks for the dono. And thanks for watching over from the UK, man. We appreciate you. Shout out to our friends in England. We love you. Hey, John Carew. Hey, thanks. Appreciate your coverage of all these great happenings. You are making a difference informing the public. John. Thank you, John. Thank you for being here. Thanks for the nice dono and supporting us. We hope so, man. And we appreciate you watching and being a part of it. And actually, we appreciate the fact that you care about the issues. Right? I see posts from people that makes my blood boil. They're like, you know what the best thing you can do with your life is? Tune out of politics. It's like, what are you talking about? Why? So that you can just give away your right to self-governance and just allow other people to govern you? What a ridiculous thing. Like, this is our birthright of self-governance. We have to stay involved and stay connected. And I'm honored to spend the time together with you. Thank you, John. Really a nice comment. Thank you for the dono. Hey, biology always wins. What's going on? What is shameful about SAT is that Secret Service missed every time that they had to shoot. Sorry if you covered this already. Yeah, well, apparently there's not a clear indicator that Secret Service agent who was shot by this guy. So they say he fired his weapon. We just saw that in the detention hearing, but not that he shot the agent. So I think that's still yet to be confirmed. So like it might have been friendly fire that actually shot that agent. And yeah, hey, Cliff Meggs, thank you, Cliff, shared this one from Il Donaldo Trumpo. Looks like it's that same image that we shared earlier, courtesy of Eric Schmidt. Let's see what this one looks like. And oh, it's the president. All right, so it's the president. A little music on that one. But Trump came out. He's after the Supreme Court win. He's just making the South great again, baby. Yeah, no more racially gerrymandered maps. Thank you, Mr. President. Nicely done. Nicely done. Hopefully we see that coming soon. Thank you, Cliff Meggs, for that one. Hey, Tim Jake. Thank you, Tim. Thank you, Tim, for bringing in 5 new members. Cincinnati Chimney Sweep. We got J.R. Williams. We got Mike Stack in the house, WHM, and Tommy Robinson, all gifted members. And I think we'll forego the after party today. Yesterday we had an after party and it like cut out halfway through and our internet is just up and down right now. My apologies for that. But we'll be back Friday. Yeah, Friday we'll be back with our members only morning stream. So we'll see you new members. And tomorrow, presumably, we can do an after party. We'll be back home tomorrow. So thank you, Tim Jake, for that. We got Biology Always Wins. More membos coming in. What's an enigma? Well, it's like a mystery wrapped in a riddle. Yeah, that's right. Hey, Biology, thank you for bringing in 5 new membos. Mad Jess is here. We got Mr. Denny Bacon in the house. Tony Shetter. Welcome, Tony. Bob Runk Horst in the house. All gifted membos, courtesy of Biology Always Wins. We'll see you tomorrow for the after party. I think that makes sense. John, hey, I don't trust Todd Blanche from John. I don't see the Comey charges having any teeth. They may not. Yeah, I mean, there's kind of a big black box of mystery out there that we don't know much about yet. We don't know what other evidence they've got. They may have no other evidence. If there is no other evidence and it's just his photo, and they have to prove the standard that we talked about yesterday in Counterman versus Colorado, which is that they need to at least show like a recklessness, which would be a careless disregard. They're going to need something unless they presented some evidence to the grand jury otherwise unknown. You just said that. I feel like his recent moves are superficial and only done to get the AG position. The Chinese have a saying called Duao Bang Xiao Shou, which means little talk, more help. Little talk, more help. Amazing. This feels like what is happening. I hope I'm wrong, though. Yeah, I understand that. I think it's okay to have trepidation about any person, especially right now. Like, yeah, it does feel he's gunning. He's making moves right now. No question. Like, he knows that. I don't even know what that means. Todd. We all know you know what it means. I mean, that's what I'd be doing. I'd be like, let's go. What does Trump want right now? Like, I want this job. So I'd be indicting everybody. I mean, honestly, I'd be doing that anyways, but you get the point. You really, like, if you're operating at level 10, you want to turn it up a couple notches to really make it shine. This is your time. This is your time to shine. And there's a counter to that, I think, in that if he gets too aggressive, then during any confirmation hearings, he's not going to get confirmed, right? So he also has to balance it out that way. So the senators might just say, like Tom Tillis might just say, how dare you indict James Comey, and then not ultimately approve him. So some of this might be leading to that. But Todd, I like to give people the benefit of the doubt. I think Todd was a good soldier during the prior Trump prosecutions. I know there's, photos of him sitting down with Caitlin Collins. Like, I haven't forgot about that. I know there's talks about him being a prior Democrat. Like, we remember all of that. But oftentimes, people have epiphanies and people can meet the moment. And I like to hope that people can do that. Like, Pam Bondi had an opportunity to meet the moment and to be anchored up there amongst the stars, and she couldn't do it. That doesn't mean Todd can't do it and really become a transformational or formative attorney general. And he's been around for a long time, and I think he's put the work in. So it's almost like proof of work leads to some value. He put the time in, he put the work in when it was not really fortunate or fortuitous for him to do that. So I hope, it's fingers crossed. We like to hope for the best, and hopefully he can get there. But I would agree, like, there are many other charges that Comey is responsible for, not an Instagram post. I'd like to see him also bundled into the grand conspiracy case. If they can't get him on any of the other lying to Congress charges, they're appealing the Congress, the disqualification of Lindsey Halligan. So I hope you're wrong too. I hope we're both wrong, John, about any doubts that we have. Biltong, premium biltong from Biltong USA. It's high protein, keto friendly, no additives, U.S. source beef, authentic South African flavor. Get some now. Go to biltongusa.com. Use code Robert, and you'll save 10% off. And you'll get some delicious meats. Rob, what's up? Dems always cry systematic racism. SCOTUS just eliminated it. Dems created systemic racism. Yeah, well, racism is like a sword and a shield. It's like you can claim it if you want to get something, and you can, if you're being attacked for something, you just claim racism, right? The other side is racist, so you have to give me extra districts. If you try to take away my districts, you're racist and bigoted. All right. So it's like no matter what you do, you're on the receiving end of being a bigot. Hey, Mike Stetson, what's up, Michael? MSM falsely claims this weakens the VRA. It's wrong. Yeah, no, you can still bring a racism claim under the Voting Rights Act. Like they didn't obliterate that. You just have to show a different standard. It doesn't give you a reason to get a district by saying that if I don't get the district, that is racism. But if the map is drawn erroneously and you can disentangle the racism from the political explanation, Alito gave us an example. He said, if you draw a map, like an algorithm draws a map that looks like it accomplishes all the political goals, but it's also creating majority and minority districts, and they flip that, you can infer that there's racism there and actually file a claim and even win on those claims. But you can't use the act to say that because there has not been a district created, that itself is racism, and then you have to draw a new district for them. So it's a big win, but it's not what they're claiming it is. But that's normally the case anyways. Rob, what's up? Cole Thomas Allen was there to protect the administration. Not from Rob. Thank you, Rob, for that one. Doan, what's up? Who took the warning call from Allen's brother at the New London, Connecticut Police Department? And is that law enforcement officer still employed there? Yeah, great question. Yeah, and Trump talked about that too. I don't know. And what did they do about that? Like, who is the next call? Did they call Secret Service and Secret Service let it go to voicemail? If so, who's that agent? Right? What's the chain of custody of the information? Who did it go from, to whom, and where did it land? Great question, Doan. Yeah, great question. Hopefully we get more on that one. We'd like to see the answer to that. Thank you for the dono, Doan. Indoctrination. Thank you for rating the stream. Here's a seashell, which I think says, those are O's, right? F-O-O-K. I think that's right. I love it how CNN downplays what Comey did by pretending he just took a picture of seashells on the seashore. It reminds me of this cool formation of seashells I found on the beach near me, which says F starfish, K CNN. Thank you for that, quad cam. What a beautiful one. Those are nice shells. You must be on a very extravagant beach. Quad cam. Hey, looks like Florida just passed the new redistricting map. Florida passes DeSantis redistricting map that could net the GOP 4 seats. We are in the middle of a redistricting war. Democrats want to play. We have to play back. It's what they've done to California, what they've done in the Northeast. Only way to play is to play and to fight back. Hey, Natalie, no grandbaby girl yet. Induction at midnight. From Natalie. Oh my goodness. You got a baby girl coming? Well, prayers up for mama and papa and your family, Natalie. I'm sure you guys are just excited as heck. It's going on right now. 1 year happy anniversary. Look at that too. We got a baby and a happy anniversary all on the same day. How amazing is that? Thank you, Natalie. Well, we're going to be praying for you guys, and it's going to be the most beautiful birth, and it's going to be just a brilliant baby just coming right out of there and just saying that was a heck of a delivery. We can feel it already. Hey, the Rubos. Oh, man. G-Gum's got a bad back. I didn't know that, G-Gum. I got some back problems myself. Hey, and the Rubos have sent me some good prayers on this. They say, we decree your lumbar spine L54322N1 is healed by the stripes of Jesus. We have faith that every word of God is medicine to your flesh. You are receiving them as medicine now. But he was wounded for our transgressions. He was bruised for our iniquities. The chastisement for our peace was upon him, and by his stripes we are healed. Isaiah 53:5. Jigum, Sorry to hear that you got that back pain, man. It's the worst. And Rubos, thank you for the amazing prayer and for the amazing salt at rubosaltshop.com. Check it out. Hey, all right. So friends, thank you for being here. Thank you for that, for those donos. Thank you for checking out Eric's house. The link, I actually don't know if it's in the description below because I might have botched that today, but I will add it as soon as we're done here. And so thank you for checking that. I think I did botch that. What a doofus. Anyways, so thank you for checking it out. Thank you for those donos. I will add it here in just a moment. And we'll say what's up over there. We've got this one dropped from Crazy KPM on Locals. How y'all? What's up, Crazy? Good to see you. Sadie dropped this one. Oh, Ken Paxton is suing for birth tourism. Amazing. Thank you, Sadie, for sharing that one. Suing for birth tourism. Rella Della, they will provide additional information on his collusion. Talking about Comey, presumably. We'll see. We'll see what, maybe his DMs were subpoenaed over on Telegram or on Instagram or whatever. And what's going on? Just another Albertan says it would appear that Alito has authorized Virginia's gerrymandering if done legally according to the Constitution, which it wasn't. Political is not racial. That's right. Yeah, they don't even hear the cases. Also, California versus Sheriff Bianco not contesting the issue, just election fraud to win the issue. All across the country, Dems can't win their policies or redistricting without rigging the polls, lying about the issue, and circumventing the safeguards of the constitutional law. Then they act like children when called out vis-a-vis Nancy Pelosi et al. You're exactly right about that. Yeah, generally, if they're partisan gerrymanders that are done legally according to the Constitution, court just says that's a political issue. Like, go take it up with your elected officials. It's not for us to decide. But if there's other problems, racism, or they, have a bad ballot question, or they violated the 90-day requirement, or they multiplied issues into one ballot measure, which they shouldn't have done that, then it becomes justiciable because there's a violation of the Constitution in one of those regards. All right. So, friends, thank you for being here. We'll pause on the day. We're heading back to DC tomorrow, so we'll be back home, and we'll get back into the regular schedule of all of our activities. And we'll be looking forward to, of course, seeing you back here tomorrow. No comments on X. No problem. We'll see if Jim is streaming, and then we can forward you guys over there if you want to go check that out. But we'll pause here for the night, and then we'll come back tomorrow. So we'll be back regular time tomorrow. It might be an hour late because we're going to be on the road or so, but if we can get out of here at Decent, then we'll be back at the regular time. But it's been a lovely stream. Thank you so much for joining us. Thank you for subscribing. Thanks for checking out Eric's house. I'll drop the link in the description because I think I botched that when we were scheduling today. And friends, I hope that your evening is beautiful and amazing. Thank you to our incredible mods who mod down the fort for us, keeping things nice and orderly. Thank you, John. Thank you, Muffin Rando. Thank you to Donut Mind Me. We got K-Bean, we got Carrie B, Neuro D, Janek, Dog Digger on the Rumbles, Geegum Geegum, Elliot, and just Rhonda modding the fort down for us, keeping things nice and orderly. And it's been a lovely day. Happy Wednesday, middle of the week, all downhill from here. We'll come back tomorrow to see what the Thursday has in store for us. And until we do, I hope your night is pleasant, your dreams are peaceful, and you wake up refreshed and restored and ready to join us tomorrow, because we will be back here. And in order to do it appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night. Sleep very well. We'll see you right. Is that Joey? All right, come on in here. We got a late breaking Joey announcement.
Oh, what's up, dudes?
All right, this is Joey in the house. All right.
What's up?
What's going on?
I'm good. I just listening to Fox Century. All the deep music in my head.
You got Music Century? Fox Music.
No, like X-Men movies like Fox Century.
First Century Fox.
Yeah, that, yeah.
Nice.
All it. all 8 logos. It's all the movies from the Deadpool or X-Men movies. Or
Yeah. You want to tell people about your treasure you found?
Oh, yes. I found that jewelry from the Titanic movies.
What's it called?
Heart of Ocean.
You found the heart of the ocean in the sea?
Yeah, you got it.
How did you find it?
On the different side of the beach. Like, first one there, the second one on the other side.
I know, but what did you use to find it?
My metal detector, this guy who got me.
A metal detector?
Yep.
Nice. And you dug it out?
Yep.
And what was it in?
In a tin can. I remember my Terminator head. That's me.
You found a Terminator head and the Diamond of the Sea?
No, yeah, it's a whole ocean.
The heart of the ocean.
Yeah, that's the name of the ship. It was wet, like no south.
Yeah, the Titanic is buried that way under the ocean, right?
Yeah, that's it.
Amazing.
It's 1912.
Yeah, people are asking about your old shirt. How come you're not wearing a nice shirt?
I like these shirts a while. It's my pages.
You kind of your PJs right now?
Yeah.
Because you're on vacation, you're just kind of lounging?
Yes, I do.
Nice.
Yep. Hey, don't forget my people, swipe more Terminator face, so like a different kind.
More Terminator face swaps.
Swaps, yeah.
You like those? Do you like the last ones you got?
Yeah, well, last one is okay. I want different ones. Like I sent them already.
Nice.
Like a kind of cop or personal True Eyes. Like those ones I do not have.
Okay, so you need the other Terminator movies with face swaps.
Like Schwarzenegger face.
Schwarzenegger, so your face in for Arnold's face.
Yeah, not his anymore. I'm better.
Amazing.
Always, I'll be back.
What's for dinner tonight?
Takeout.
Takeout?
Yeah, I love that.
What kind of takeout?
Just thinking like chicken fingers or something.
Chicken fingers.
And fries.
I think you said that last time.
No, that's last night.
All right. Well, anything else you want to say to your fans?
Don't forget to swipe my faces.
Don't forget, and thank you.
Yes.
And I love you, stuff like that.
I love John too. Before you swipe my T2 faces, I need a T5 or T6 and T7.
All right.
All those ones, I need that too.
All right.
Yes.
Well, your fans say hi. They're really happy that you came in and said hi.
Yes.
And they're excited to see.
Yep.
We make a treasure video, didn't we?
Oh, yes, we did.
We did. So you found one that was probably from a pirate ship and one from the Titanic, right?
Yep, that's it.
Man, it's pretty cool.
Yeah.
Well, we're excited.
I'm going to watch my 5th century back in my brain.
All right, man. Love you.
Nice to meet you, dudes.
All right. All right, friends. So that's my brother, Joey. He found 2 tins of buried treasure out there on the beach with a metal detector. Pretty amazing. In one of them, there was a Terminator head and some other stuff that came clearly from a pirate ship, obviously. And then the other one came from the Titanic, and he got the heart jewel that apparently that old lady threw into the sea. He found it. So amazing. Thanks for saying hello. That's my bro. And we love him. All right. So apparently he wants some chicken wings or chicken fingers tonight, which is the same thing he wants every night. But we're on vacation, so how can you deny it? Anyways, thank you for saying hello. Thank you for all of your love, sending it back his way. He loves coming to say hello to all of his fans out there. And so we'll pause here, my friends. It has been a lovely stream. We'll come back tomorrow. We'll get into it again. Until we're back, make it a great night. Sleep very, very well. And we'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. together we are. Watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through